the red serial number at the top of this document?
Yes.
See that? It's an official document from your office.
Yes.
Kept in the course and scope of your duties as circuit clerk.
Yes.
When I scroll all the way down, this is the petition of Ms. Archie file. So I'm just zooming down all the way down to the very end. My question is, are there any certificates of compliance signed by 2 lawyers in this state? Yes or no?
On that page, no.
No. Let's go back, and I want to be thorough. Let's look at each exhibit that was filed with the petition. So we got number 1, civil cover sheet. That's a one-page document. It's not there, is it?
Correct.
Let's look at exhibit 2, the petition and the contest and the amended petition. It's 8 pages. This is still the exhibit to the petition. It's an official document file, where you see at the top,
The heading.
the red serial number. Let's zoom all the way down. Do you see a certificate of compliance signed by 2 lawyers in good standing in this state?
No.
Let's go back. That was exhibit 2. Go to exhibit 3. That's an email, right?
Correct.
We'll click it, hit view. Again, it's an official document because we see again at the top, the red serial number, right?
Correct.
Any certificate of 2 lawyers in good standing in this state signed to accompany this petition?
No.
No. Number 4, exhibit number 4, the same petition. It's a 93-page document. I submit to you that's the one we've already put into evidence as the recap. No, it's not it. But I'll download it. I want the jury to see it. 93-page recapitulation report. It's downloaded. It's official because it's got the red serial letter at the top, right?
Yes.
Zoom all the way down. You see 2 certificates signed by lawyers in good standing in this state, 2 different firms to support this petition.
No.
So go back. We're almost done with this exercise. Exhibit D. I'm sorry, exhibit 5. Same official document, see the red serial number at the top?
Yes.
3-page document, we go down this document. That's a letter signed by Mr. Archie himself, isn't it?
Yes.
Any certificate of 2 lawyers in good standing in different firms to support this petition?
No.
And finally, exhibit number 6 to the petition. See the red serial number at the top?
Yes.
This indicates an official document in your office, correct?
Yes.
2-page document, Jackie Amos. Is that a certificate of consultation by 2 lawyers signed to support Ms. Archie's petition?
No.
Mr. Wallace, you agree with me. He asked you about this statute. Let me show you another statute. First, President.
Yeah.
Mr. Wallace,
Mr. Wilson, you can come back up if you want to.
That's okay.
this is 23-15-9-27. You see that?
Yes, sir.
Can you read the sentence after the 10 days? Can you read that sentence that says the petition?
The petition for judicial review should not be filed unless it bears the certificate of two practicing attorneys stating that they have each fully made an independent investigation into the matters of fact and of law upon which the protest and petition are based, and that after the investigation they believe that the protest and petition should be sustained and that the relief prayed in the protest and petition shall be granted.
According to that statute, your office shouldn't even file Mr. Archie's petition. Isn't that correct?
I can't say that's correct.
Okay, well, does it comply with the statute inasmuch as you just testified, there are two missing certificates of compliance by two licensed attorneys in different firms?
Correct, yes.
It doesn't comply with the statute, does it?
No, sir.
Now, a lot of time was spent on these videos. I was present in some of them, you were present in most of them. Your job as a circuit clerk, pursuant to statute, is to maintain custody and control of the election materials, is that correct?
Correct.
And I remember when you were the assistant to Barbara Dunn, the then circuit clerk. You remember those days?
Yes, sir.
What was the election commissioner's office at that time?
Right down the hall in the Hinds County Courthouse.
Yeah.
Right down from the circuit clerk's office.
In the same building in the basement, correct?
Yes, sir.
And so, for all of those elections that Ms. Dunn,
Objection, gentlemen. This is not a dispute about elections that happened 10 years ago.
Judge, he went into
What's
this.
the stone? And then, what's your objection?
I'm saying that this is irrelevant. I mean, what's him having to do 10 years ago with Ms. Dunn and how they do elections and
Yep.
that?
Your objection is based on relevance?
Yes, Your Honor.
It's overruled.
And so, you would agree with me that your office then was closer in proximity to the election commissioner's office, correct?
Correct.
But the board of supervisors, for its wisdom, decided to move the election commissioner's office to a different location, is that correct?
Correct.
And whose decision was it to allow that new location to serve to house the election materials?
The board of supervisors.
Not Zach Wallace, right?
Correct.
That's above your pay grade, right?
Yes.
The board made that decision, right?
Yes.
So, let's take it step by step. Because a lot of discussion was put in to where the jump drives, flash drives, the election material is actually housed, right?
Yes.
If it's housed in your office in the basement, is it under lock and key?
Yes.
If it's housed in your office in the basement, is it subject to restricted access by the public?
Yes.
If it's housed in your office in the basement, are there limited individuals who can view it and the scope of what they can do? Is it limited?
Yes.
Same questions. If the information is housed in the new location for the election commissioner's office, is it under lock and key?
Yes.
Is it limited to public review?
Yes.
Is the public restricted by the persons and the times and the efforts of when they can review that material?
Yes.
And so, if you accept Mr. Wilson's line of questioning, that because the materials are not in your office per statute, there wouldn't every election, not only the ones in August 2023, wouldn't every election be in there?
Can't say that.
Now, folks, let me show you the statute. This is what he asked me. This is 23:15, 9/11. So you read the first sentence, right?
Yes.
Remember you read that, where it talked about making sure that the ballots are resealed, you remember that?
Yes.
But then go down to the second sentence and read that.
At any time within 12 days after the canvass and examination of the box and its contents by the by the election commission or executive committee, as the case may be, any candidate or his or her representative authorized in writing by him or her shall have the right to full examination of the box and its contents upon 3 days' notice of his or her application, therefore serve upon the opposing candidates.
So stop right there. So the candidate has a problem with the election, and they want to review the election materials. They give 3 days notice, and in your office, in coordination with the election commission, you comply with that request. Is that right?
Correct.
And that's what you're doing in these videos, right?
Correct.
So regardless of whether you're in the basement of this building or in the election commissioner's office, you still get Mr. Archie access to the documents and materials we saw. Is that correct?
Correct.
This is the important part. All the videos that he put in evidence, those are all after August 8, 2023, correct?
Correct.
Had the vote been counted at that point?
Yes.
It had been calculated at that point.
Yes.
And it had been determined that Anthony Tony Smith won that round by a count of 4,687 votes, and David Archie got 2,810 votes. Is that fair?
I can't verify.
Now, Coach,
You may.
Yes, according to the document.
and if the math is correct, that will be a 1,877 vote difference. Is that correct?
Yes.
Mr. Wallace, did you observe the commissioner, election commissioner's tally of this particular vote?
No,
You weren't there.
I wasn't there.
All right. You would agree with me that just because the materials are kept in a different location, not in your office, the same scrutiny is there for the public in terms of restrictions to get access to that material. Isn't that correct?
Correct.
You're an elected official, so are the election commissioner, right?
Yes.
You have statutory obligations, so are the election commissioner, right?
Yes.
In one video, you were looking for precinct bag number 29. Remember that? I was there that day. Remember that?
Yes, based on the video.
And
Yes.
that bag was eventually found, was it not?
Most likely, if I recall correctly, yes.
And it was eventually produced to Mr. Arch and his team and inspected, correct?
I think so.
P9, he asked you about the blue bags that were laid out on the floor you were looking at. All of the 26 precinct bags for District 2 were in fact present and accounted for. Isn't that correct?
At that time, I can't say, but I know no bags were lost.
Okay, so say that again.
At that time, I can't say that all bags were there, but no bags were lost.
There was much to do about chain of custody, and your role is when the election workers leave the precinct, they bring the blue and red bags respectively to your office. Is that correct?
Correct.
Those bags are unsealed, correct? With the metal seal on each bag, right?
Most of them were, yes.
And after that, they were turned over to the election commissioner's office for tabulation. Isn't that right?
No, you know, the bags contains, and they're correct me if I'm wrong, affidavits and paperwork, and the ballot boxes contain just ballots.
Okay.
So the jump drives will have all the numbers on them.
Right. Jump thumb drives. Again, those are in fact subject to encryption, correct?
Yes,
So there's a software that prohibits ordinary Joes like me from getting one of those disks and examining the content, correct? As a matter of fact, if that happened, it would destroy the content on the thumb drive, wouldn't it?
I'm not sure about that.
But there's scientific, technological mechanism to prevent tampering, correct?
Correct.
Now, he asked me about the paper boxes that are in your vault, and I think he testified those were affidavit and absentee ballots. They were all mixed up. Is that correct?
Correct.
Okay. Why is it not a concern that they were mixed up at that point?
I would assume because the resolution board do not go in no particular order. I think that they do go in order, but when they scan in, they don't scan all of precinct 1 and all of precinct 2. They scan them in as they process the ballots.
And after the resolution committee makes a decision about a particular ballot, it's tabulated or not. Isn't that correct?
Yes, correct.
So he's making a point about the affidavit absentee ballots in a box in your vault being all mixed up. But they were mixed up at a point when the tabulation already occurred, correct?
Correct.
Voted already certified.
Yes, correct.
Anthony Tony Smith declared the winner
Correct.
by 1,877 votes.
I'm not sure about the number, but okay.
Council officer asked me about the integrity of the election. Remember that
Yes.
question?
I'm gonna say for object to that in equal case.
Oh, Judge got it first.
You may.
So I was, could you read that sentence that says the key?
Your Honor,
Hold up.
raise objection, that is a summary of what the case is, I think.
No, wait a minute, you're gonna have to speak a little louder.
That's a summary of what a case is, it is not the case. I believe it would be more appropriate for council officer to print the actual case out and give the quotation from the court and not the summary from Westlaw or anyone else.
This is a case itself.
Wait a minute, director.
Case,
Yes. What are you talking about?
well, it looked like it was the,
Well, hold on. That's why I showed you.
Wait, hold up. Don't make me put you in jail. What's your objection, Mr. Wood? You withdrawing it?
yeah, no problem.
Ms. Watt, can you read that to the record for us?
The key in deciding whether an act not in strict compliance with statutory election procedures renders the election void is whether the act is such a total departure from the fundamental provisions of the statute as to destroy the integrity of the election and make the will of the qualified electors impossible to ascertain.
Whether or not it impacts the integrity of the election, or we can't determine the will of the voter. That's what the case says, right?
Yes.
In this case, anything that you found that found a violation of the integrity of this election? Yes, sir.
Hold up.
Your Honor, would council mind letting us know what the name of the case is on this case?
What's the name of the case?
Exercise.
It's over v. Curry, 147, Southern Section 286.
You got it?
That's fine.
In this case, with all of your involvement, your review with the parties, everything we've seen, was there anything you found that would destroy or impact the integrity of this election? Yes or no?
No.
Is there anything you found from your review and working with these parties that the will of the qualified voters was impossible to ascertain? Yes or no?
No.
Was this a good election?
Yes, it was good election.
Was it a fair election?
Yes.
Did anybody else in the August 2023 primary challenge the election? Losers or winners?
I can't recall.
And again, whether or not the signature books were recovered, chain of custody, all these red herrings, all of this happened after the vote had been tallied and certified, correct?
Correct.
No further questions.
Mr. Wilson?
A moment ago, he showed you the NEC filings on this case. With court's indulgence, my computer's up. I'd like to show him the Supreme Court filing that is relevant, that is basically Exhibit 31.
You may do so.
Can you hear me, Mr.?
Yes.
Okay.
Yes.
When you filed this, or rather, when this matter was filed 2.5 years
Are you about to question him?
Well, as I'm typing, that's the question.
Huh? No, at the podium is what I want.
Okay. Your Honor.
Okay.
Ms. Wallace, you testified moments ago that when I showed you the thing that was filed at the Supreme Court, you said that based on your recollections, you had emailed that to the Supreme Court, right?
I don't know if I emailed it to them there. I don't know exactly how I got it.
Or that you may have taken it there. Is that right? Either way, it came from you, correct? Therefore, whatever was filed with the Supreme Court had been given to you, right?
Yes.
Let's see what was actually filed with the Supreme Court. Unfortunately, I don't have internet connection. How do we do this?
What do you need to do?
I need an internet connection here for this. Yeah, I know. Here. You say that? Let's go to the Court Institute's website. All right. We're going to put Mr. Archie's name in here on the general docket, as you can see. And we're going to go down to 2023 AP. AP 1003. Do you see that on the screen right there where I'm announcing this?
Yes. Yes. Yes.
All right. And you'll see that on 9/8/2023, the case was created, correct?
Correct.
Okay. And that was the day Mr. Archie filed his petition with your office. Is that correct?
Correct.
And so it was your testimony a while ago that whatever it is in this file right here before the Supreme Court is what you provided to the Supreme Court. Is that correct?
Correct.
Okay. It's a pretty big file, taking a second for it to load. First of all, let's look at the first page. What is the very first thing you see at the top right?
My file staff.
Okay? So, that is the official designation that you got this paper and sent it. Is that correct?
Correct.
Okay? Go all the way down to the end. And also notice, the file stamp is September 8th, 2023, correct?
Correct.
And the Supreme Court's file stamp is September 8th, 2023, correct?
Correct.
So this is all the same day, correct?
Correct.
Would you mind reading what I have posted, which is on page 132 of the document that you filed with the Supreme Court of Mississippi?
I can't, all I see is the heading, it says attorney's certificate.
Okay?
Thank you.
All right, so you would agree with me that's an attorney's certificate, correct?
Correct.
Okay, let's look at page 133. Is that an attorney's certificate?
Yes.
Okay? So, would you agree with me then that the Supreme Court of Mississippi, on that day, you filed this paper with the Supreme Court and had both attorney certificates in it, correct?
To be honest, I can't say it. The reason I can't,
You just testified a while ago that you actually brought that up there.
He was answering.
You got an objection?
Yes, sir. He
State your objection.
interrupted his answer. Let the witness answer.
Overruled.
You just said a while ago that you caused to be delivered this document to the Supreme Court of Mississippi, yes or no?
yes,
All right. And if you caused this document to be delivered to the Supreme Court of Mississippi, does not that presuppose that you had this document in your possession?
yes, I was,
Okay.
yes,
And if you had this document in your possession, that would presuppose that Mr. Archie gave you this document. Is that correct?
yes,
Which means that he would have filed this document with the two certificates. Is that correct?
I would say yes.
Okay. Now,
Based on how you asked me.
all right. Now, he's pointing out and trying to make a lot of hay that you didn't put that on MEC, correct?
Correct.
Okay. I want to notice something on the very first page. Would you mind reading who the defendants were on this case when it was first filed?
First one, I say Hinds County Democratic Executive Committee, Jacqueline Amos, Sandra McCall, Anthony Tony Smith,
Tony Johnson, Relation Systems and Software, ESNS, and Hinds County Circuit Clerk Zach Wallace, John Doe 1 through 5, Jane Doe 1 through 5.
So you were a defendant in this action when it was first filed, right?
yes,
Okay. And so, I'll just leave it at that. Sorry. Leave it for a line of questions. Now, you made an inconsistent statement in your cross-examination. Do you recall when I asked you at the end of my direct examination earlier, I asked you if the failure to keep the chain of custody would compromise the integrity of the election? You said it would. Did you not?
I don't remember you asking me like that, but, yes,
Okay. But I did ask you, and I did say, and I suggested to you, and you agreed with me, that the integrity of this election was compromised, correct?
we'll bring up questions, yes.
Okay. But then, you contradict yourself when he cross-examines you, because he asked you in this case, there is no integrity problems.
From my standpoint, no.
You can't have it both ways, Mr. Wallace. And Ms. Wallace, I'm gonna bring to your attention a case. Since our esteemed co-counsel, and I gave you a copy of this earlier, the case of Waters versus Janine. Okay? And I cited it earlier, it's case number 2004 DC 00007 SCT. It was from 2003. And I'm going to get you to read a few salient paragraphs from this, because this describes what the law is in this situation. Okay? All right, first thing I want to do, if I may approach on,
You may.
read paragraph 63, it's short.
Similarly, in the case at bar, the evidentiary value of the sealed ballot boxes was lost the moment the seal was broken on the ballot boxes. Moreover, like Allen, the contents were disposed and made available for fraudulent practices.
So what the Supreme Court is saying there tonight is that when a sealed ballot box is unsealed, it becomes exposed and made available for fraudulent practices. Is that what it said?
Correct.
The court's indulgence. Now,
You may.
I want you to, you can read the whole paragraph if you want to, but that's what was your name.
Another critical violation in the circuit clerk's relinquishing her statutorily mandated duties to take the charge of the ballot boxes after the completion of the OMR counting process, which was completed in the early morning hours of August 6, 2023. Instead, the ballot boxes was kept in various storage rooms at the courthouse, and after the county election commissioners improperly dumped the contents of the 6 precinct ballot boxes from District 3 into 2 non-secured cardboard boxes from the farmer's market. A trustee, which we presume to be the jail trustee, among other persons, moved these card boxes around from one room to another at the courthouse.
All right, so we talked about a while ago, and I showed you in section 911 what your duty was to secure the ballot boxes and keep the ballot boxes yourself. Do you remember us going over that?
Yes.
Correct. And you admitted that you had not complied with that statute.
Correct.
Okay. So not only did you relinquish your statutorily mandated duty to take charge of the ballot boxes, let's talk about this. Just like in this other case, you kept the machines and ballot boxes and material and all of that in various rooms, right? You had a vault, you had the election commissioner's buildings all over the place, right?
Correct.
Okay? And then on top of that, just like this, y'all had absentee ballots in an open box that didn't even have a seal on it. Is that right?
Correct.
And the Supreme Court of Mississippi called that a critical violation, did they not?
Correct.
All right, let's look at another few paragraphs in the mini case, or the Waters case. Let's call it that. I can't pronounce it.
I think this is beyond the scope of my office. I never mentioned the water stage, never brought it up.
Your Honor, he opened the door.
Your objection is beyond your cross.
Yes, sir.
Your objection is overruled.
Thank you, Your Honor. In the same case, in just paragraph 60. If you wish, go ahead and please read from paragraph 60 through the end of the page on each. Yes, sir, paragraph 60.
In accordance with section 23-1591, 911, subsection 1, the ballot boxes should have been persistently maintained and monitored by the circuit clerk, who had a duty to safely keep and secure the ballot boxes against any tampering, both before and after any box examination. However, as evidenced by the record, section 23-15-911-1 was unquestionably violated when on August 18, 2003, Wilbur Redmond cleaned out the 6 District 3 ballot boxes and placed the contents into 2 cardboard boxes, sealing the 2 boxes with a single piece of tape. Importantly, the cardboard boxes were never sealed. Statutorily mandate prescribes that the ballot boxes be sealed immediately following an election in order to preserve the election day results. In this case, the boxes which may have been sealed at one time were not only left unsealed and accessible, but their contents were commingled with the contents of other District 3 boxes. When the circuit clerk finally took possession of these cardboard boxes on August 22nd, she proceeded to add additional tape to their exterior, fearing that the security of the ballots was unsatisfactory. Unfortunately, the taping did nothing to cure the inappropriate handling of the ballot boxes prior to that time.
So, Mr. Wallace, it doesn't matter if you've got a lock and key to the vault. It doesn't matter if you've got a lock and key to the room. It matters that you follow the statute. Is that right?
Correct.
And the statute says the boxes have to be sealed, right?
Correct.
And your boxes weren't sealed, were they?
Correct.
So you violated the statute.
Correct.
And because you violated the statute, the integrity of this entire District 3 election is in District 2 election with David Archie is in jeopardy. The integrity is in question. Is that correct?
I would say it's in question, yes.
Tender witness. I tender witness, Your Honor.
Mr. Wallace, how many people voted that day?
I'm not sure at this time.
You have a record of it?
Yes, I do have a record.
No, this was, we offered in the recalculation, it's in evidence, it's D1.
I know it is, but I want how many absentee ballots were voted that day?
I can find out. I can pull it up in the system.
Was that only when they turned the recalculation in? Was that on that? How many people voted?
Yes.
How many absentee?
I'm not sure at this time.
But that was on that when it was turned in.
Yes.
Judge, it's D1, can I just get the document, show it's one?
You can get the document. You'll have an opportunity to ask them anything you want to.
Thank you. Thank you. Your Honor, we couldn't hear your question. I'm sorry, and I know you were asking a question, and we couldn't hear it over here. Could you repeat your question?
I've asked him how many people voted in that election, absentee and in person. And then I wanted to know how many absentee ballots were returned. I need to know all of that. That's what I wanted.
The recap sheet is showing for David Archie, 2,810. For Anthony Tony Smith, 4,687. That's the total.
That's the total of the two candidates.
Yes, sir.
Is those numbers,
Exhibit D1.
You can't look at that.
No.
you finished with this witness?
I'm finished with this.
All right. May he be full and finally excused.
Yes, he may be.
Y'all need a bathroom break?
Yes.
All right, we'll take a 15-minute recess, and we'll be in recess for 15 minutes. Everybody else remain seated. Remain seated. We'll reconvene at 3 o'clock.
Thank you, Your Honor.
I can bring up this stuff. They are perfectly welcome, just like they did before, come down our office and they open the building. I was not the person at the time, so I could only advise them, come down and go back to it like they did. All those things, rather than excuse me, it's not that simple, brain on this stuff. It would be easy to use the thing out, because it is a lot.
Service. The service is from the chief. When we speak evidence of trial, we have the right.
You gotta be.
Yeah, yeah.
It's not the same. We need to have to tell them that we got officers that use this wall there. If they want to go there, and we will put, but it is there. It's there, it's fine.
This is an election contest. And when there is an election contest, contents and ballots are very,
You told me what I need to know. You didn't do the thing.
Okay.
You good. Mr. Wilson, who's the next witness?
Sandra McCall.
Huh?
Sandra McCall.
All right, bring him in.
Yours in the courtroom, y'all.
Come on around, young lady. Okay, I need you to face me and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Okay. Now, I need you to speak a little louder, help your voice is real soft, okay?
Yes, sir. Yes, sir.
Mr. Wilson?
Thank you, Your Honor. Ms. McCall, please state your name for the record.
My name is Sandra Griffin McCall.
Well, Ms. McCall, it's a pleasure to meet you today. I don't think we've ever really met before today. I am Mr. Archie's attorney, Matt Wilson, and we brought you today based on a subpoena. Is that correct?
That's correct.
Can I approach the witness and show her the subpoena?
You may.
That is the subpoena that you were issued, is that correct?
That's correct.
Okay. I would ask that it be
Ms.
marked.
McCall, would you spell your first name and your last name?
Okay, Sandra, Sandra, McCall, McCall.
I would ask that this be marked as next number on the list.
What number?
Trying to find out. Okay, on the numerics, thirty something. So this would be number 35. Yeah, mark for number 35. As this
Is that the subpoena?
yes, Your Honor.
Okay.
Mr. McCall, this was addressed to you, and I believe if you read this indented paragraph, one of the things we asked you to bring to court today. Would you mind reading that indented paragraph for me, please?
All items in your possession, custody, or control that pertain in any way to the primary election for the Democratic nominee for Hinds County, Mississippi, Supervisor District 2, that was conducted on or about August 8, 2023, including but not limited to ballot boxes, thumb drives, ballots, absentee, affidavit, express, etc., voting machine tapes and reports, tally sheets, machine tapes, all used and unused ballots, and ballot accounting form, etc.
Thank you.
You may.
Now, Ms. McCall, when you were served with that subpoena, you filed a letter with the court, is that correct?
That is correct.
This is the letter that you filed?
Yes, it is.
Now, has this been admitted as plaintiff's exhibit 36, is that right?
That'd be 36.
Yes, sir.
P36, okay.
That's it right there. Okay. Yes. Okay. If I may approach you.
You may.
Mr. Hall, did you write that letter by yourself, or did you have any assistance?
I wrote the letter myself.
Very good. Would you mind reading the letter into the record?
No, come on, check, it's already there, let us speak for itself.
What's the purpose? It's already.
Well, okay, let me just ask her some pointed questions. That might be a good. Ms. McCall, in this letter, you state that the policies and procedures of the Hinds County Democratic Executive Committee clearly require that any member who is working for a campaign when two Democrats are running for the same position must take a leave of absence. Is that correct?
That is correct.
Okay. And that you complied fully with this requirement. Is that correct?
That is correct.
Okay. And as a result, you had a leave of absence, is what you're telling the court.
That is correct.
Okay. And that you were not involved in or possess any knowledge of the preparation or administration of the primary election held on August 8th, 2023. Is that
That
correct?
is correct.
And that the Hinds County Democratic Executive Committee hired Ms. Linda Sanders, I guess there's two S's, to administer the Democratic primary, compensating her $1,500 for those services.
That is correct.
And that is your testimony today under penalty of perjury, correct?
Yes.
Court's emotions. Now, who did you, I don't have the letter in front of me, I apologize, but was Eddie Fair that you were working for?
Yes, I was his campaign manager during that time. Eddie Fair.
And he had a contestant in his primary, so you couldn't?
Yes.
This has been admitted as defendant's exhibit D1, may I approach?
You may.
Alright. And on page, exhibit C is first page exhibit, and then page 2, then there's a certificate here. Would you mind reading this official recapitulation certificate in its entirety, please?
Democratic Executive Committee will prepare 3, is that what you want me to do?
Oh, I'm so sorry.
Or do we, the undersigned
Yeah, we-
Democratic, okay, Election Commission hereby certify that the foregoing is a true and complete recapitulation and statement of the results of a primary election held on the 8th day of August 2023 in the county of Hinds, Mississippi, and that the foregoing correctly shows the vote cast for each person and for the opposite the respective names at said election.
Okay, thank you. I'll make sure to read some more in just a second, but for now, would you explain to me, I know you were on a leave of absence at this time, but would you mind explaining to me what the recapitulation is?
Yes, I was on a leave of absence until the election was over with the night, okay? Then as each time that I'm on leave of absence, when the election is over with, I come back and resume my duties as secretary of the Hinds County Democratic Executive Committee. So I came back the next day, and what happened was is that at that time, when you say, what can I explain to you that, is that it's the election votes, it's the affidavit votes, and it's the absentee votes. And those are compiled and given by the technician. And it goes to Zach, and Zach prints it out for the different parties.
Well, I understand. Now,
You may.
well, you led into what I was about to ask you about. I noticed here that your signature is on this recapitulation.
That's right,
Correct.
as secretary.
May I look at the other thing? Thank you. Yes, this is fine. Okay. Now, one other thing I want to look at on this recapitulation I find interesting is that in this report, this covers all of the candidates for all of the various races in Hinds County. Is that correct?
You would have to ask Mr. Wallace about that.
Well, I guess what I wanted to get at is, one moment. Of course, indulgence. You said that you were representing Mr. Eddie Fair, is that right?
So, yeah, I was Mr. Fair's campaign manager.
If I may. You were Mr. Fair's campaign manager, but you certified his victory over Mr. Lewis, is that right?
What do you mean, I
You
certify?
sign your name on the recapitulation.
Well, yes, that's what, for every candidate, that was the Democratic Party's, thing that I took to the Secretary of State's office, yes.
But Mr. Call, wouldn't that be a conflict of interest?
Why would it be Mr. Fair, one?
Well, you're certifying that you won.
Yes,
Okay, so that would be a conflict of interest because you're his campaign manager.
There's no object to argument if she's answered the question.
Objection sustained.
Now, in this exhibit, this letter, you told the court that I was not involved in and possess no knowledge of the preparation or administration of the primary election held on August 8th. You said that, correct?
yes.
Okay. But then if you don't have knowledge of the preparation or the administration of the election on August 8th, then how could you have signed the recapitulation?
I'm not understanding your question because that was after the election.
Did you participate in any way on the resolution board?
No, that
Did
is
you know-
against the law.
It's against the law, so you had nothing to do with the resolution board.
No.
You had,
You would have to check with Mr. Wallace.
did you attend the resolution board meetings?
No,
Did you have anything to do with the ballot counting of the resolution board?
no.
May I approach the witness?
You may.
Okay. Would you mind,
What's that document number?
it is number 164 on the NEC.
Okay.
Okay. Ms. McCall, just for the matter of record purposes, just read this style.
Comes now claiming
Title.
David Archie's response to Sandra McCall's motion quash trials.
Okay. Now let's look and see what we've got. Buried in this thing are some pictures. Ms. McCall, is that you in that picture?
Yes, opening affidavit ballots.
At the resolution board?
No, the resolution board was in a different place with Mr. Wallace.
So why were you opening up absentee ballots if you were not on the executive committee?
Sir, that was after, like I explained, after my leave of absence.
So your leave of absence conveniently ended when you were counting the absentee ballots of the guy that you were running the campaign for, Mr. Fair, is that correct?
No,
Okay. What about this right here? Tell me about this picture.
that is after the affidavit ballots were counted, the ballots from the resolution board, and the tech ran those particular ballots, and we were looking to see if anything made a difference in the percentage of the voting.
I asked it to be marked as my next exhibit.
I don't object to the motion itself as a response to a motion. I have an objection to the vote.
What are you objecting to?
It's Mr. Archie's response to a motion to quash.
Oh,
I have any objection to the photographs that he has.
okay. What is his
The
motion?
purpose I'm doing this is for photographs.
Okay, the objection don't.
That's just be marked. You marked it, and I should be immediate.
All right. Is that gonna be 37?
I believe it's 37, is that right? Now, Mr. Cole, let's look at this recapitulation one more time. I have another question. Okay, approach. Look on the second page. There was an amended signature. Is that right? Okay, amended.
It wasn't an amended signature, it was an amended date.
Amended date, okay? All right. Did you get a court order to amend the recapitulation?
No,
one more question for you, and I have, this is in plaintiff's exhibit P34, which was admitted. When we looked at it, actually, I'm gonna walk up here with this one. Before we look at the map. Would you mind reading the names of the people who signed that?
Jacqueline Amos, Sandra McCall, Ruth Johnson.
Okay? Who is Jacqueline Amos?
She was at the time chair of the Hinds County Democratic Executive Committee.
Archie was the chairman of the Hinds County Executive Committee. Okay? Now there is something that is attached to an exhibit to this petition that's been admitted into this. Now approach.
Right.
First of all, what's the name of the person who sent that text?
Jacqueline Amos.
Now, I'm going to ask you to read something that has a little bit of profanity. Who said that?
Judge, on the court, Ms. Amos is not here. She was subpoenaed and she was not served. This is a statement allegedly attributed to Ms. Amos.
What are you about to ask?
I'm asking her to read something that's already in an exhibit,
Let me see.
but I wanted her to redact anything, is all I'm saying.
Judge, it's cumulative, it's already in evidence, and it's not her statement.
Wait a minute. What do you want this for, Mr. Wood?
I wanted to show that the president of the board of the election commission had a bias against Mr. Archie, and as a result of that bias, she would have had the motivation to, not her, but the other person, based on her allegation here, her own statement, which is now evidence, would go to the heart of the case and the motivation of why people would want
What's
to
your-
get one.
What's
It's
your,
not proper under 403, it's inflammatory, beyond that. If you wanted Jacqueline Amos here, subpoena her and let her testify.
It's already,
It's cumulative.
your objection is overruled, I'm gonna let it in.
now, we have TV cameras here, so you don't have to say the word. Okay, we can just use the word yeah. Okay? Okay, well then, let me say this. Isn't it true, it says here, Jackie Amos texted, but I'm effing David Archie on site. Is that what it says?
Yes,
Okay.
that's what it says. Was that the day that he jumped on us?
What are you saying, Mr.?
I remember,
That's not a question.
okay, I'm sorry.
So she was at that time the chair of the committee, correct?
That's correct.
Turn to exhibits and see if there's any more questions. That I need any more questions. Now, just to clean a few things up here, the recapitulation board was inside the circuit clerk's office, right? When you do the recapitulation, that was inside the circuit clerk's
That
office.
was the tech from the ES&S and Zach Wallace.
Okay. You testified that you were not at the resolution board meeting, is that right?
No, I was not.
But you were at the circuit clerk's office, is that right?
I was at the circuit clerk's office.
I have two small videos, very small, exhibit 28.
No, that's fine.
All right, this will be exhibit 29, P29.
P29.
Actually, Your Honor, I'll use it. Let's do P30. Now, is that you sitting in the back there, right inside the door of the circuit clerk's office?
Yes,
Okay. And that's during the resolution board meeting, is it not?
no,
It's not?
no,
What
sir.
is that?
That is a meeting of when we were looking at the affidavit ballots. I remember it well because it was the day that Mr. Archie tried to attack me and I had to call the security.
Objection.
No, you asked the question.
Mr. Martin,
Judge.
I'm not gonna tell you again. Now, if you got an objection, you state your objection.
Objection.
What's your question?
Well, my question was simply, was this the resolution board meeting? She's answering and testifying beyond that and saying stuff.
She has opportunity to respond. open the door.
Your objection is overruled. You may go ahead and ask your question.
Judge, just for the record, he objected to his own question.
It's overruled.
Okay, his objection is overruled, so she asked.
I will object. Yours is overruled. You may proceed.
No, Your Honor, for the record, he objected to his own question.
Your Honor, I didn't object to
I've already made my ruling. Let's move on.
All right, let me ask you.
Come on, Mr. Wilson.
Your Honor, that's all I have right now. We'll come back and read the rest of this question.
Mr. McConnell, your answer to the last question, Mr. Archie did what to you?
Mr. Archie, was screaming.
Objection, relevance.
Judge, he asked her about the video.
That was not,
It's overruled. Go ahead.
Go ahead, Mr. McConnell.
Mr. Archie was screaming and hollering at me that he was not gonna allow me to, take an election or, whatever from somebody. And he kept on and on, just on me. And I asked him to back away. And then, somebody called security, and security escorted him out of the courthouse.
When did this happen?
It was one of those days that just got, just real bad.
Did
And
he use profanity?
he used everything.
And since that time, he and the people helping him continue to threaten.
Wait.
Right?
Yes,
Hold
sir.
up.
I'm
What-
being intimidated.
What's the objection, Mr. Wilson?
the objection is completely relevant. I was simply asking her if she was at the board that day.
Overruled.
Haven't they, the folks who hang on Mr. Archie, haven't they continued to threaten you?
Yes,
How so?
Mr. Larry White gets upon my body, almost to touching me with his breath, as if he's threatening me and telling me that I'm going to jail. And he continuously does that. Mr. White comes to my house and knock on my door. And even though I would have gotten emails from the attorney about the change, Mr. White has made it a habit of coming to my house. When he's around me, he tries to just get right up on me.
Your Honor, that is dealing with the certain.
Overruled.
I mean,
Who is Mr. White?
Mr. Larry White,
He's
he's in
sitting in the front row, with the gentleman with the mask. Is that,
yes, that's,
Mr. Larry White you're referring to?
yes.
What has he done?
He tries to intimidate me repeatedly, and he keeps telling me, I'm going to jail, you're going to jail. Other people don't have anything to worry about, but you're going to jail.
Over your handling of this election?
I didn't really handle it over me coming back to work, and he said that I'm going to jail, and he gets in my face.
Objection, this is hearsay.
You know,
It's
to
overruled.
me,
Have you reported the conduct of Mr. Archie or Mr. White to the authority?
when Mr. White left my house last week, I did talk to an attorney about doing something because I'm just tired.
Now, Ms. McConnell, your testimony is that you worked with the Hinds County Democratic Executive Committee, but you took a leave of absence as relates to this election, correct?
That is correct.
And at 7 p.m. that night, when the polls closed, the next day, your work resumed. Is that correct?
That is correct. As secretary, yes.
Any
Yes.
statutory issues with that at all?
Not that I'm aware of.
All right, let me show you what's been marked D1, the recapitulation. That person,
You may. Mr. Wilson, have you seen this?
Yeah, it's D1 measure, okay.
I'm going to direct your attention to the supervisor's race, David Archie and Anthony Thomas Smith. You see that?
Yes.
Could you tell the court what the final tallies were for, let's start with Mr. Smith first.
Mr. Smith, 4,687.
All right, and what about Mr. Archie?
2,810.
All right? Now, even though you weren't involved, were the absentee and affidavit ballots for the August 8, 2023 election, were those ballots for District 2 combined, were they less than 1,800?
I'm sorry, say the question.
Okay. You said you had been involved with the counting of the absentee and affidavit ballots.
Yes,
Were those ballots less in total? When you total them all up for District 2, were they less than 1,800?
yes, for Mr. Archie, yes.
Okay. No, I'm talking about the total number of absentee and affidavit ballots.
Okay. Now, yeah, they were, yes, as
You recall.
the recall.
Right, because we're only dealing with a 7,500 vote total combined,
That's
correct?
right, that's correct.
So I think it stands to reason, but I wasn't there, so I'm asking you.
Mm.
The absentee and affidavit ballots that you dealt with for District 2, when you combine them, add them together, was that total less than 1,800?
Yes, I believe it was, yes.
And the difference in this race is 1,877, correct?
Yes, yes.
Of course it does. Council, I was asking about the conflict of interest. Remember those questions? You remember those?
Yes,
Even when the totals came out that night, August the 8th, 2023, your role with the campaign for Indy Fair had ended, correct?
that is correct.
And the next day, that's when you assumed your role as Secretary of the Democratic Executive Committee,
That
correct?
is correct.
And that's why your name is listed on page 2 of D1 certifying the results, is that correct?
That is correct.
Turn to the second page and tell me when the results were certified.
It was amended and certified on the 18th.
It would have been 10 days after the election, correct?
That is correct.
All right, no further questions.
It was certified when,
On the 18th,
of what?
August 2020.
One second. Your Honor, a few questions, I'll leave that.
To what, Mr. Wilson?
Just a few questions.
Oh. You're witnessing.
Ms. McCall, he made a point that you signed the recapitulation on the 17th of August, is that right? It was 10 days after the election, is that correct?
It was amended 18th.
18th, the amended one, so that's 10 days after the election, is that right? Okay. And if I'm understanding under section 911, and I believe he read that in the evidence earlier, you've got 12 days to raise a fuss if you're a candidate, right?
I believe that is correct.
Okay? So, Mr. Baer's opponent would have still had the opportunity at that point to raise a fuss.
Protection relevance.
It is relevant.
Overruled.
Mr. Baer's opponent, while you were signing that document, still would have had time to object and to contest his election. Is that correct?
I think you.
Yes or no question?
Yes,
Okay. All right. So, at that point, you still would have been acting as his campaign manager because if he raised a fuss, you would have been having to come back and help Eddie defend this.
Mr. Lewis lost by such a wide margin.
Well, I mean, they're trying to say that my client lost by such a wide margin and he shouldn't have filed a contest. My question to you is, It makes no sense, does it not, for your leave of absence to have ended before the votes were completely counted and the election contest could not have happened, correct?
No.
Now, as we were looking at that video earlier, we saw these people in the front that were tallying ballots and whatnot. That is the resolution board, is it not?
That is correct.
Okay? And the resolution board in that video was handing you ballots and you were handing them back, were you not?
No, I was not.
You were not? You were never doing anything like that.
No.
You were not communicating with them.
Judge, be honest, scope of my problem.
Overruled.
Why were you there when the resolution board was meeting? And why were you in the circuit clerk's office while the resolution board was doing their duties of correcting and altering ballots?
Sir, you have to understand the process, and the resolution board is under Mr. Wallace. He had them there. We were working with the affidavit ballots, and as the resolution board worked with the absentee ballots, what they would do is they would get them ready to be scanned, just like we were getting the affidavit ballots ready to be scanned. So we didn't have anything to do with the resolution board, Mr. Wilson, is that right?
Yeah, that's right. So, but you were getting affidavit ballots that had not been counted yet. You were getting them counted and scanned, correct?
The process,
So yes or no question?
yes.
Okay. You were doing that when your candidate, Mr. Eddie Fair, was still getting votes counted for him, just like Mr. Archie was getting votes counted for him, and Mr. Smith was getting votes counted for him, right?
Yes.
Okay. Is that not a conflict of interest, ma'am?
No, sir, it's not.
So, you working for somebody else's campaign is actually counting the ballots for your candidate.
Overruled.
Oh, wait a second.
Thank you.
It's a simple question. You were working and counting ballots for a candidate that you were representing as his manager, yes or no?
I was counting affidavit ballots.
Yes. And those ballots would have been, and it would have included people for Eddie Fair, just like it would have included every other candidate, correct?
Correct.
So you were counting ballots in the race that your candidate was running on, yes or no?
Yes.
Okay. So why then should the Secretary of State believe your signature when you had a vested interest in what was happening in that race?
You would have to ask the Secretary of State's office.
Now, you testified on my direct, you were not at the resolution board.
Sir, what do you mean at the resolution board? The resolution board was in an area that Mr. Wallace had put them in, and we were in another area working with the affidavit ballots that the commissioners had accepted.
But you're no further from them than you are from me right now, Archie.
That doesn't mean a thing, because we weren't working with them. Mr. Wallace was working with them.
But you were counting ballots.
Affidavit ballots.
And even though you testified under oath and you wrote a letter to this court saying that you had nothing whatsoever to do with the administration of the primary election.
I had nothing to do with the preparation of the election for that election in 2023. Mr. Archie had already lost when I came back from leave of absence.
Well, wait a minute, you were still counting his absentee ballots, weren't you?
I was not counting absentee ballots, please. I was counting affidavit ballots.
Well, they're still ballots.
And most times, affidavit ballots are very, very limited. The commissioners will tell you that a lot of them are not approved. So what the people counting the absentee ballots was the resolution board, and they have the last word.
So if you're not counting the absentee ballots, and the resolution board is counting the absentee ballots, but then again, you're scanning the ballots.
Counsel, you after that ceremony. Let's move on.
So is it your testimony that you were there or you weren't there?
You saw, I was there.
Okay. Okay. All right, attendant witness.
You full and, yes, witness may be full and final excuse.
Yes, Your Honor.
All right, you may step down. Thank you, sir. Who'd you call next?
Cynthia Walker.
Who?
Cynthia Walker.
Cynthia Walker.
Your Honor, could we take a brief restroom break or something? Is that possible? Also, get some- Never.
You need a break.
Well,
You need a
I
break?
need a little break real quick to get something. Ready for the chief.
Okay, we'll take a 15-minute break.
Yes, sir. Clerk office.
We're gonna take the break, Mr. Wilson.
I'm sorry. Oh, I'm sorry. Yeah. I'm sorry. Does that the acoustics in here are off?
Okay. We're gonna take a 15-minute break. That's what you wanted.